Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, Managing Partner of Hull & Hull, a firm specializing in estate, trust, and capacity litigation. I am very pleased to be joined today by counsel to our firm, David Freedman, together with our co-founding partner, Ian Hull. So in continuing with our back-to-school theme, because we do have Professor David Freedman with us today, I thought we might talk a little bit about the legal tests that are required to prove a will. Ian and David, we hear so much about the term probate. What is the difference, David, between proof in solemn form and proof in common form?
Okay, these are old terms, and we still use them. When someone dies and they leave a will, or if they die without a will, someone has to apply to the court to be able to administer their estate. And most of the time, there's not a problem. They put in an affidavit, they put in an application, and the will, if it looks fine and it doesn't raise any concerns with a judge or the registrar of the court, it's proved in common form, just with the affidavit. Occasionally, there may be something wrong on the face of the will, or there might be an objection that's raised, and then it becomes necessary to prove that will by evidence. And that's the difference. Solemn form is proving by evidence. Common form is proving by the affidavit and the application itself.
And I think I always look at it, the difference between what we do substantially at our firm is we're chasing down the solemn form cases. And the solicitors out there who are getting what are the standard wills that don't have controversy to them are the common form solicitors. And it's an easy way for me to remember the difference between the two.
And we also hear a lot when we're talking about proving wills, this concept of testamentary capacity. David, what exactly is testamentary capacity?
To make a will, you have to have the capacity to understand what a will is. You have to have the capacity to understand what you own. And you have to understand, or have the capacity to understand who you should be providing for. That doesn't mean that you have to make a will in a particular form for particular people, but you have to know the consequences. And that's what the law demands. If there is a question of incapacity, then that will may not be valid. A person that makes a will, for example, if they are suffering from Alzheimer's or some form of cognitive problem, can't make a valid will.
And Ian, how does that sounds to me a little bit like illegal as opposed to a medical test. Is that the case?
Well, it's true. And the courts are ultimately the arbitrator of that decision. And the courts make the final decision. They look to medical sources. And when you're proving a will, the three prongs of the proof of the will come from: one is the medical source documents, or what the practitioners, the medical attending practitioners are saying, or what our caregivers saying, or social workers. So the medical component is one. The second component is what the lawyer is going to say if a lawyer was involved, which is not, a high percentage of cases when wills are prepared. And the third component is just what we call lay people evidence. What do people around the testator, what do people around the will maker say about that person's behavior? And it's funny because each one of those prongs has their own strengths, and you can't say one is more important than the other. It all depends on each facts in each case.
And it's a little bit more complicated in some ways, because in one of the other episodes, we talked about holographic wills.
Yeah.
And if there's a holographic will and a person made it in their own handwriting, and we know that they were ill at the time, or other people think that they were ill at the time, then a court is going to be very reluctant to admit that will to probate.
It's a good point. So definitely we're understanding what the test is to have a valid will. What about some of the formalities? What exactly does due execution refer to?
Well, I think it's sort of a nice roundup to this whole question of what are the legal components, because you have to have your head in the game, and you also have to follow the formal compliance rules of a will. And some provinces have some flexibility, which I'm sure David's going to talk more about. But in Ontario, anyway, it's a very strict: two people all in the same room, two witnesses, and plus the person signing it. And there is really no variation on that theme in Ontario.
Mm-hmm.
Right, so that if you do all of that, and you have the will properly witnessed, and there are what are called affidavits of execution, affidavits from the witnesses, then that allows the will to be accepted in common form. But if there are problems with those formalities and you don't comply, then the will is not going to be valid. And as Ian said, some provinces allow for a judge to say, well, you came close. You got one witness, and one witness is not enough. But not in Ontario. In Ontario, if you're not strictly compliant, then the will is not valid. And this is where solicitors that are drafting wills have to be very careful that, in fact, they supervise the execution of the will and not just the will itself.
And that's really interesting when you think about the fact that a holograph will, a handwritten will, doesn't even require any witnesses and doesn't require that same level of execution, but yet is equally valid.
Absolutely.
Turning to a discussion or a little bit about this whole concept of undue influence, David, what is undue influence?
So undue influence is not restricted to the law of wills and estates. We don't like to enforce gifts if someone was coerced or someone was exploited. Let's say during their lifetime, a vulnerable person is taken advantage of by a caregiver and that they give a gift to the caregiver, and we would say that that will is not valid. Well, it's the same thing with a will. If a person wrote a will and someone was coercing them or forcing them into giving them a gift in the will, then we would say that that gift is no good. A person can be influenced properly by their family or their lawyer or someone to structure their will in a particular way, but if they're unduly influenced, if they're forced or coerced or tricked or something like that, then the gift that they give in the will is simply not valid, and that has to be determined by a court.
And Ian, do you have something to add to that?
Well, I think the only thing I would add is that it's very difficult for lawyers and people who don't practice in this area to determine what does it mean to be unduly influenced. Mm-hmm. And obviously, as David points out, family or your wife can influence you, as we all know, or I know anyway, I won't speak for you, and it isn't something that maybe even comes close to the threshold of coercion. Mm-hmm. And some of the cases talk about the test almost being arm twisting. But that is where the gray area comes in, combined with the fact that the evidence is almost impossible to find, because when you're unduly influenced, it's almost always done in private. So those two components make any tests for undue influence very difficult to prove in courts, but they're an important component of making sure valid wills are sustained and tested properly in a trial.
And David, how is undue influence different from the term suspicious circumstances?
So undue influence is where we know that someone has coerced or arm twisted or something like that. Suspicious circumstances are when a court feels that there's something about the will that requires more proof. And it may be as a result of undue influence. It may be that someone is threatening to withdraw personal care services or something like that. And then again, we go back to solemn form to make sure that the person had capacity, duly executed their will, that it was what they wanted to do. And they were, it's either they had witnesses there or they did it in their own handwriting. And it's a hard concept because one party can feel that they can bring circumstances to the court's attention, but a judge themselves can say, there's something not right about this will, and I need more evidence before I'm going to allow it to be admitted to probate. The big problem in the law of wills and estates, we can't really consult the person that made the will when we need the information from them to figure out whether it was well made.
Ian, do you have anything to add to that?
I think it's a good problem, actually. It brings some good uncertainty to these cases. So. But no, I don't have anything else. Thank you.
Okay. Well, thank you very much for joining us here today. And thank you to all of you watching for joining us at Holland Hall TV.